In this episode of Dil Se, I'm going to have a conversation with one of perhaps the tallest leaders of the country, a man of great intellect, a man who, even if you don't like him, you'll have to respect him. He's a man of few words, very sharp, very measured, and a man who has been in politics since 1972. Held many portfolios. He entered the Congress in 72. In 84, he became a minister, deputy minister of commerce. Then he became a minister in a subsequent government, in Narsimha Rao's government. He held the Ministry of Commerce twice. And of course, then he went on to become the finance minister, gave a dream budget to this country in 1997. Then became the finance minister in the UPA, became home minister. So a lifespan in politics and an understanding of economics that none can match. And that man is Mr. Chidambaram. Thank you very much for being here.
Good evening.
But we're going to talk not so much about the various portfolios you held, but on the PMLA. And the reason is that it's much in the news. It's being misused on a daily basis by this government. And they say that you brought in the law.
I have the book with me. It says Prevention of Money Laundering Act 2002. It is Act 15 of 2003. This is Mr. Vajpayee's government. This law was passed in Mr. Vajpayee's government. For whatever reason, they did not notify it. It received the assent of the President on 17/1/2003, long before UPA came into office. In the meanwhile, pressure was exerted by the FATF, Financial Action Task Force, of which we are a member, saying, why are you not notifying the act? So when we came into office in 2004, the pressure has mounted so much, and there were even questions, why is this act not being notified? Therefore, we had no option but to notify the act. But I did make a couple of amendments and then notified the act. So this is not my baby or the UPA's baby. This was inherited. And little did we know at that time that this will be grossly misused. There is a way of reading an act, there's a way of applying an act. A law has to be read reasonably, fairly, and applied reasonably and proportionally. This law has been completely misused, which is why I've been saying, if the Congress comes back to power, we'll repeal this law and reenact a better law.
But that's a question of when and if.
Well, I don't know, but this is on top of the agenda. This law has vested arbitrary, untrammeled power upon one investigating agency, which is now more powerful than all the investigating agencies put together.
But let me ask you, I think people don't know, those who are watching this program will not know, what is this FATF?
See, it's a Financial Action Task Force, a voluntary body of practically all the major economies of the world. And unless you become a member of the FATF and address the issue of money laundering, they will not exchange information with you. Other countries which will place large restrictions upon capital flows, inflows, outflows, especially sharing of information. We are now part of the global economy, and we need information. We need to give information, take information. We are nowhere near the scale of money laundering that happens in, say, Russia or even the United States those are gargantuan proportions. But Indians abroad, NRIs, Indians with businesses abroad, have transactions. And unless we fall in line with the internationally accepted norms of money laundering and the law to curb money laundering, we will be excluded from the information exchange.
Well, you know, since we are friends for a long time, I can call you PC. I just want to know from you, the genesis of this law is related to drug money being laundered and terrorist money being laundered, or mostly drug money.
Mostly drug money and terrorist and human trafficking.
And human trafficking. So
these are the major, say, businesses in which money is laundered.
If that's the genesis of the law, this schedule of the PMLA makes scheduled offenses, means offenses which they consider scheduled offenses, which involves perhaps every law in this country, right, including provisions of the code of the Indian Penal Code, like 420, which is cheating, forgery of a document. So the result is that in any civil action or criminal action on cheating, you can arrest a man, and the bail provisions are such that he will not be released on bail.
See, this schedule has made this act worse.
But who made the schedule?
Yeah, all right. The schedule was inserted initially in the original act. It was a very short schedule. It had Part A and Part B. And the so-called lesser offenses were in Part B. But this schedule has been amended twice or more. Major amendments were made in 2013 and in 2018. 2013, this act came into force on 15/2/2013. Again, the schedule was amended in 2018. The amendments to the schedule have made the matters worse. And this is because the pressure from the Directorate of Enforcement that unless these offenses are added, it's not possible for them to file a comprehensive complaint or a charge.
But if you have an offense like 420 that is cheating, right, and under ordinary law you can get bail, the moment you add that in the schedule, an ordinary action on cheating, a criminal action on cheating also becomes a scheduled offense.
Correct.
And people can't get bail. So I mean, why should this have happened at all?
This was wrong. There's no question about it. This was wrong. And this schedule should have been kept short and tight. The schedule should not have been extended. But perhaps there was pressure from the FATF to add more offenses to the schedule. I mean, I can't remember now. This happened, this exercise happened during the period I was away from the finance ministry. But I will now admit that this enlargement of the schedule was clearly wrong.
Because you were finance minister from 2008 to 2012.
Yes.
Right? And then you became a home minister. So why, when this schedule was amended in 2013?
No. 2008 to 2012, I was not finance minister.
Yeah, exactly. You were finance minister from 2004 to 2008.
2004 to 8.
So when you were finance minister in 2013, this amendment took place.
Yes, but this is an amendment. The law is notified as Act...
but this was expanded. The schedule was expanded at that point in time.
Act 2 of 2013. But the schedule had been drawn up, and I think the bill was introduced or passed earlier.
I know that, but what I'm trying to say is that this expansion of the schedule took place during our time.
Oh, during UPS time?
Yes,
no
that's what I'm saying.
about it.
Yes.
But who was the finance minister who introduced the bill? I can't remember now. It doesn't matter. We have to take collective responsibility for the schedule, which is why I say I have no hesitation in admitting the enlargement of the schedule was wrong.
Yeah. But then, of course, the problem is then when this act was challenged and when the Supreme Court rendered that decision, which I think we've been trying very hard to question it and say that, look, it should be referred to a larger bench. And in the context, what's happening in this country by the misuse of this act, we're not seeing the court actually looking at this whole law and the impact of it on the polity of the country.
See, in my respectful view, respect to the three-judge bench which decided the challenge to the PMLA, that judgment is contrary to well-settled principles of law. And the review petition that has been filed is a comprehensive review petition which questions major conclusions. Unfortunately, the review petition has not been posted for hearing. Remember, your viewers should know that the review petition was admitted by a three-judge bench, of which Chief Justice Ramana was the lead judge. He clearly said in his order, on two issues at least, this judgment deserves to be reviewed.
Correct.
He didn't specify the two issues, but we all know what the two issues are. Subsequently, benches have questioned one or other of conclusion. And then when fresh writ petitions were filed, a three-judge bench heard arguments led by you for almost 2 or 3 days. And they were pretty satisfied that the matter must be referred to a larger bench for review. So I don't think the fact that the Supreme Court has pronounced this act by and large valid should inhibit us from discussing the weaknesses of the judgment. This must be reviewed, and the sooner it's reviewed, the better.
The danger of not reviewing is the following. We're at the cusp of the 2024 Lok Sabha election. If this law is not reviewed, the manner in which this law is being used against every opposition leader in this country will in fact turn the tables as far as...
I have no doubt about it. They have arrested ministers.
Yes.
They have arrested a chief minister.
Correct. It's never happened in the country before.
It never happened.
Yes.
And this was not the concept of federalism that was thought of by the founders. Now imagine if the state government starts arresting union ministers. This is a mischievous thought.
But state governments can't use that law, unfortunately.
Not under this law.
Yeah.
Every minister belongs to a state. He will have property there, he'll have family there. You can always level a charge against a sitting union minister, and the state police can arrest him and throw him in jail. This is completely destructive. You see, the right thing to do is, for example, when there's a charge against a judge, the law today is, you know better, that you will have to bring the material to the notice of the Chief Justice. If the Chief Justice permits alone, you can do an investigation. And before anything happens to him, he will be persuaded to tender his resignation. So this is the ED, allegedly acting independently, is raiding ministers, raiding chief ministers, questioning chief ministers. If the tables are turned, and if the state government starts doing that under the regular criminal law and other state laws against union ministers, this country's constitution will break down. Governance will break down.
I think it's already broken down, if you ask me.
Well, it's already broken down.
What is left if the ED goes only to the opposition states,
yes,
targets opposition leaders, targets sitting chief ministers, right, threatens to arrest them, especially when we are in the cusp of a 2024 election, what's going to happen to our polity? And then the other thing is, that when you fight an election, every candidate, when he fights an election, has to disclose what criminal charges are pending against him.
Yes.
And there are, if you go to the Election Commission's website,
Yes.
you will find that many of the ministers of the centre
Yes.
and those who fought elections have several criminal charges, including chief ministers
Yes.
in various states.
Yes.
So the ED, doesn't go to them. It doesn't.
As to the best of my knowledge, ED has not picked up an FIR in a scheduled offence against any union minister of the BJP government.
But why doesn't the court take note of that fact?
Well, the court will say, you approach the ED, give information, but the ED won't do anything.
No, I'm saying something else. The court knows that only opposition leaders are being targeted. All that the court has to do is to have suo moto, start an action,
Yes.
tell the ED to disclose to them all information regarding every minister or every candidate who has fought, of all political parties,
Who has got an offence.
who has got an offence pending against him, and ask the ED
Why?
as to why they have not taken action against them and why are they taking action against the opposition leaders, and the cattle are out of the bag. We'll know exactly how partisan this institution
I
is.
tweeted there are some 390 or so BJP MPs.
Yes.
And I think all over the country there are several thousand MLAs.
Yes.
And especially those who have defected from other parties to the BJP, which is why we call the BJP the great laundry machine, washing machine.
Yes, yes. Political laundering. It's not money laundering, but political laundering.
Yeah. Moment you cross over, all your offences
all your sins are washed away.
All your sins are washed away. I can name chief ministers, I can name union ministers, I can name state ministers who have got charges against them, investigated by the BJP government, CBI or any other agency. And then even ED has investigated them, but once you cross over, all files are
So then what does it tell you about the ED?
It shows that it's a completely politically driven agency.
So why should the court not intervene?
It should. It should. I hope some judge listens to your interview, this conversation, and asks fellow judges, why are we not intervening?
Exactly. The other big issue that I think that needs to be discussed is that the three-judge bench of the Supreme Court, when dealing with the PMLA, said it's not a penal statute.
It's not a penal statute, and these are not police officers.
Well, that's a separate issue, but first,
I think both are important. Both are important. If they are police officers, this becomes a penal statute.
Right.
If it's a penal statute, the officers will become police officers.
Absolutely.
And today, the only evidence which the ED has in many, many cases is to coerce people to make statements, sign it under section 50 or so, and then say you've made a confession.
Absolutely.
Which will be completely ruled out in any criminal court under criminal law and Indian Evidence Act. But the ED's best evidence is coerce statements or confessions from the accused or the accuser's accomplice.
No, the significant thing about this law is under the Code of Criminal Procedure, when you call somebody, you call him either in his capacity as a witness when an offense is being investigated or as an accused. If you call him in the capacity of a witness, which you have to disclose, then he has to make a statement. If you call him in his capacity as an accused, then he has to seek the protection of the Constitution.
He has a right to
in the PMLA, you do not the ED doesn't have to inform the person concerned who they call whether they are calling him in the capacity of an accused or in the capacity of a witness.
This is the point which Mr. Arvind Kejriwal has raised. And I have seen summonses, any number of summonses, where information according to the schedule, and the schedule is blank. The schedule is blank. You are summoned to bring information according to the schedule, and the schedule is completely blank.
Absolutely.
You don't know which is the predicate offense for which you're being summoned. You don't know the allegations which led to the ED to start taking action. You don't know what information you're supposed to bring, what documents you're supposed to bring. You go there with a blank mind and he can ask you any questions. And I have not seen a case where ED does not come out next day with a press statement, 7 hours of grilling,
That's
8
right.
hours of grilling. And this is contrary to all fair procedure.
Not only that, I think it's a very serious issue for the reason I remember that they made such scandalous allegations about properties located outside of India.
Yes.
Right? And since then, several years have passed. What's happened to those allegations? It just shows they wanted to defame individuals. They wanted to destroy their reputation. They had no evidence. And they just wanted to incarcerate the person concerned. Now, this is something that's unacceptable in a country governed by the rule of law.
That's why, you see, to undo the damage, the only way is to repeal this law and constitute a group of jurists and experts to draft a proper prevention of money laundering law. Nobody is questioning that money laundering is a serious offense in this interconnected world. Money laundering must be made punishable. But this is not targeting money laundering. This is targeting the alleged money launderer because he is a political person.
That's correct. That's correct. Absolutely right. Now, most people may not even know what's the difference between proceeds of crime and money laundering. Most people would not know. But let me give a simple example. If you have some dirty clothes in your home and you put it in a machine, in a washing machine, they come out clean. So the difference between proceeds of crime is like dirty clothes, and money laundering is you launder in those clothes in such a way in the washing machine that they come out clean. So if you have dirty money with you, you launder it and to tell the public that this is clean money. So if you take a bribe, invest it in property and show as if this money you already had, you're laundering it. Right? That's what the meaning is.
Correct.
Now the problem with this law is money laundering is the offense, not proceeds of crime.
Correct.
If money laundering is the offense and if you are convicted, you are punished a maximum of 7 years and in other cases 10 years, how is it not a penal statute?
No, it is obviously
it's obviously a penal statute.
Obviously a penal statute. Because the foundation of the statute is a crime has been
money
committed.
Laundering.
Crime has been committed.
Yes.
Under a predicate offense.
Yes.
The
420 cheating is a predicate offense.
Predicate offense. There's a crime has been committed. Now, a crime can be committed without money involved.
Correct.
You can murder somebody for rivalry, but there's no money involved.
Correct.
You can also murder somebody and burgle his house. The second one gives rise to a proceeds of crime.
Correct.
Murder with burglary gives rise to proceeds
or
of
ransom.
crime.
Murder for ransom. Yes.
Proceeds of crime. That proceeds of crime, if you want to charge somebody with money laundering, he must convert that crime-tainted money and to make it appear to be clean
untainted.
Clean money, untainted money.
Correct.
That he earned it as a lawyer or a doctor or a businessman.
Correct.
If that money is tainted, no question, but only when he converts the money or projects the money or makes it appear that to the world that this money is not tainted, he is guilty of money laundering. Now, unfortunately, the 3-judge bench lost this distinction, and it went on to say, which I think is plainly wrong, that every proceeds of crime becomes money laundering.
Yes.
The distinction between a predicate offense and the special offense of money laundering has been completely obliterated by the judgment, which is what we hope a new bench will understand and appreciate.
But when?
I don't know. You know better. You toil for 2-3 days trying to convince a bench. But I think there were differences between the judges, and one of the judges was retiring in a couple of weeks thereafter, and I think he just gave up the effort. I think the presiding judge, Justice Sanjay Kaul, ought to have persuaded his brethren that we must refer the matter and let a larger bench decide the matter.
Well, that matter is over now. The other aspect on this act is something that again worries me, is that Parliament amended certain provisions of this act through the finance bill.
Yes.
Right? And therefore the amendments never went to the Rajya Sabha.
Yes.
So under ordinary laws, if you amend an act, it goes to the Rajya Sabha, and if the Rajya Sabha disagrees, then the act cannot be passed.
Yes.
But because it was included in the finance bill, and some very drastic amendments were made through the finance bill, and they called it therefore a money bill, therefore the amendments never went to the Rajya Sabha. Now, that's created a lot of problems.
No, the key provisions which are being questioned today are all by money bills.
That's right.
The idea was that the Rajya Sabha should not scrutinize it.
Right.
Well, let's not mince words. The Rajya Sabha should not scrutinize it. Because if the Rajya Sabha had scrutinized it, at that time the BJP did not have a clear majority.
Yes.
It's possible that the bill would have been defeated or at least stalled. So they deliberately avoided the Rajya Sabha. And this question, whether a money bill,
whether amendments in ordinary law through the Finance Act can never be a money bill.
No, you can if you are amending a finance bill.
That's different.
You can amend it by another finance bill, which is a money bill. But when you amend such a law...
supposing that you are amending the Arbitration Act,
correct,
and you include it in the finance bill.
No, this is clearly wrong.
Clearly wrong.
All the key provisions will be struck down.
Yes.
In fact, the three-judge bench, your viewers should know, your key three-judge bench which upheld this law, clearly said in the opening paragraphs that we are not going to question the money bill. If the money bill argument is accepted, many of these provisions will go.
Yes.
Which is why we are anxious that the money bill issue must be decided by the Supreme Court, but we are trying for the last 4 or 5 years. That case is not being heard.
This is why people have been incarcerated, unfairly prosecuted under the amendments, because of the amendments, which actually obliterates the difference between proceeds of crime and money laundering.
Correct.
That's the amendment.
Yes.
And the result is that people are being unfairly prosecuted, and the court has sat for several years not to hear this matter. Now I believe that after the next constitution bench, you will have the issue of money bill being decided by constitution.
This question has actually been decided in an earlier case. What is a money bill, and whether you can amend a non-financial bill by a money bill has already been decided.
Yes.
That law is, all the judges agreed on that law. The majority upheld that law by saying that one provision has been deleted and one provision has been read down. But Justice Chandrachud called it a fraud on the Constitution.
That's correct. That's correct.
Therefore, now that Justice Chandrachud is the Chief Justice, he should take the process forward and decide this question, whether the key amendments to the PMLA could be done by a money bill.
That's right.
And going by declared law so far, I'm pretty confident that all these provisions will be struck down.
In fact, I have another concern. Assuming that the Supreme Court hears this matter,
yes,
say 2 weeks from now, and after a week or 10 days or whatever, it reserves orders. By that time, I think sometimes in March, there will be notifications issued for the Lok Sabha elections, which is likely to commence in April sometime. By the time the judgment comes, the period would have been over. So what use is it to hear the matter when before the Lok Sabha elections, you might even not get a judgment?
No, no. The judgment can't be held back for too long. Say,
No, but I mean, they've got so many constitutional bench matters where judgments have not been delivered. So they will not hurry up any particular judgment. So the result will be, even if the matter may be heard, even if ultimately it's decided in our favor, the damage is already done.
oh, the damage is already done.
Yes.
Whether the judgment comes to reverse some of the damage has already been done.
Yeah.
The point is, at least future damage will not take place in the future, because the key provisions of this
But
act
in the
will be
meantime,
struck
they'll
down.
keep on arresting people under this
They
law.
will,
This is the problem.
I'm afraid that the next targets are
Kejriwal.
visible on the radar.
Yes, yes.
And who else is the target? I can't say.
No, they are in the south also. They are targeting people.
They are targeting ministers
Yes,
now.
yes.
They are not targeting a chief minister.
Not
yet a chief minister, but they're coming pretty close to the family member of a chief minister.
Yes, I know.
In Kerala.
Yes.
And
what about West Bengal?
West Bengal, another family member of the
Yes,
chief minister.
yes, yes.
They're pretty close to that.
Yeah.
The idea is to put fear
Yeah.
and sort of put fear and intimidate them. Therefore, they will stop their opposition to the BJP. And if somebody is resolute in his opposition to the BJP, like Hemant Soren, they just arrest him.
See, the last time we had a draconian law, it was the POTA, I remember.
Yes.
Right? But the POTA affected individuals. This particular law affects institutions, affects the federal structure of this country.
Affects governments.
Affects governments and affects the federal structure of this country. Because you're using the law to bring down governments.
Yes.
Right? POTA didn't have that effect. POTA never had that effect. So perhaps it is the most draconian law in the history of this country.
Undoubtedly, one of the most draconian laws. POTA was equally draconian because it may not have affected governments, but it created huge amount of communal conflict.
That's true.
I was the Home Minister. I had gone to Gujarat and looked at their POTA cases. I asked the Chief Minister to give me a list of POTA cases. 7, 8 out of 10 persons arrested under POTA were Muslims.
Yes.
That POTA widened the divide between Muslims and Hindus.
They don't need POTA for that nowadays because you widen. Therefore, I'm saying that POTA is not necessary.
No.
But
One
I'm
of the
talking
reasons
about
why I came back and said we have to repeal POTA.
Yes.
I
supported you in big time on that matter. No, but I'm saying is this particular law impacts the entire structure of government in this country. And that's the real worry.
See, today a state government, a chief minister, cannot peacefully rule a state if this PMLA continues to hang over his or his ministers' heads, which is what has happened today.
No, it's just not chief ministers, PC. There's another issue there. What they do is they target the chief minister later, but they go to the bureaucrats under the chief minister, right? And then they call the bureaucrat, supposing an IAS officer is posted in Karnataka or in Andhra or wherever. They'll call him and they'll say, tell us your returns for the last 10 years, your return, your wife's return, your children's return. We just want to know. So the bureaucrat then thinks, why should I get into all this?
Yes.
Right? And they then start threatening him in ways, that we all know. The result is the administration comes to a standstill. And so the government doesn't move forward. That impacts on the polity because people say, look, this government is doing nothing. And the administration is frozen.
This has happened in
Chhattisgarh.
This has happened in Jharkhand.
Yes.
This is now happening in Tamil Nadu.
That's correct.
They are calling, they have got a stay from the High Court, I think, some kind of a stay. They are calling district collectors They're calling revenue officials on alleged charges of sand mining.
Correct.
Now, the district collector may have left his district 6 years ago, 5 years ago. He has moved on to other jobs. They're calling all those district collectors to say, this sand mining took place when you were district collector. This was the DRO, this was the RDO, the revenue officers, and they are taking statements from him. They are summoning him.
But on what basis? I mean, there's no money laundering involved. This is the predicate offense. Remember,
correct,
if you
but
investigate something with sand mining, that's a predicate offense.
But that distinction is wiped out. Now, the moment ED steps in, you see, my experience of cases I have looked at, ED investigates largely the predicate offense.
That's correct.
ED is not investigating money laundering.
Yes.
ED records statements which the CBI does not record.
Correct.
And in many cases, ED is added to the proceeds of crime identified by the CBI.
That's correct.
CBI says the proceeds of crime are 10 lakhs. ED adds some 1 crore, 2
That's
crore,
correct.
10
which
crore.
It can't do.
Which can't do.
Yes.
Even under the present judgment of
It
the
can't do.
3-judge bench, it can't do.
Right.
But ED goes ahead and ED does that. And ED shares this information with the CBI.
Right.
And I think encourages the CBI to expand its to charge sheet. Right. This is all.
So, the question is, under what law can the ED say, you give me your returns for the last 10 years?
No, it can't. It can't. In fact, the only offense under the Income Tax Act is one offense of making a statement under oath, etc.
Correct.
There's no other offense of income tax which is
part of the
schedule.
Correct.
But the ED is asking for which the income tax does not ask.
Right.
The ED has now become a super agency which has taken over all the powers of the SFIO, the income tax, the customs authorities, the excise authorities, the GST authorities, the CBI. It's taken over vast powers.
It's the new God. It's the new God which controls everything in this country.
Which is completely destructive of the rule of law that we have understood.
Right.
I hope that the Supreme Court will wake up to the gravity of the situation, the damage that is being caused all around, and quickly hear the money bill question and quickly hear the review petition and set this law right to the extent possible until a new government comes and repeals this law.
Quite frankly, the court should immediately set up a 5-judge bench and say, okay, till such time as we decide all matters, let this be on hold.
Yes. Sedition is put on hold.
Yes.
So there's no harm in putting this on hold.
Let this not be used for furtherance of the prospects of a political party in the election.
And especially on the eve of elections,
yes.
Unless some restraint is applied by the Supreme Court, I'm afraid this government, the government of the day, will misuse this law more and more. The next 2 months, I fear huge misuse of this law.
Well, it's sad that we have reached this state, and I hope that the Supreme Court realizes the gravity of the situation. But thank you very much.
I hope so.
For being here with me today and having this great conversation. Thank you.